thank you especially for bringing the crotch bomber into the conversation. Our next speaker, William Kelley, has been on the faculty of Notre Dame Law School since 1995. He teaches constitutional law and administrative law, and writes about a number of public law issues. He served in both the executive and judicial branches of government, most recently from 2005 to 7 as Deputy White House Counsel to President Bush, previously in the Solicitor General's office during the 1990s, and then as to experience with the judicial branch of government as law clerk to Kenneth Starr when he was a U.S. Court of Appeals judge for the D.C. Circuit, and then on the Supreme Court was a law clerk for both Chief Justice Warren Burger and Associate Justice Antonin Scalia. Thank you.
Thank you. Good afternoon. It's a great pleasure to be here. Thank you to Rubin and the Federalist Society for the invitation, and the other sponsors as well. It's a pleasure to see some familiar faces in the audience, particularly my friend Cheryl Stanton and my friend and former colleague Cheryl Stanton, who's a great lawyer if you're looking to hire somebody. That's if you're a client. She's got a great job, don't worry. Okay, I'm going to focus on practical questions. I think that it is a policy decision whether one invokes the civilian court system in this context or the military commission system. It's notable that both the President and the Attorney General have agreed that the military commission system is legitimate and available for the trial of these detainees. Indeed, in the very speech in which Attorney General Holder announced the government's intention to prosecute Khalid Sheikh Mohammed and 4 others in civilian court, he also announced its intention to prosecute 5 additional detainees through the military commission process. So we have to start from the premise that both systems of justice are legitimate. The Attorney General decided to put KSM and others in the civilian system in order to make a point, I think, in his own words, to serve our highest ideals. I think those ideals really come down to a belief in the rule of law as embodied in our civilian justice system. There are 2 aspects of that system which really give specificity to that ideal. And that is the ideal of impartial protection of rights and adherence to legal norms. And incredibly importantly, and it might be the most valuable thing we have in our system of government, an impartial judiciary devoted to deciding cases based upon law and not passion. So, will trial of KSM and others in the civilian system, using that system to pursue impartiality and the rule of law, actually work? I've seen a lot of commentary about the security risks, the classified information risks, the propaganda risks, and other sorts of arguments. The cost to the city, both emotional and financial, of going through this, strikes me as just enormous and extraordinary. And those are all matters to be weighed in the balance, I think. But I guess I'm more concerned now about, well, how is this going to work? How will these people be tried in the civilian system? They have to be indicted, and they have to be indicted for offenses against the United States. And they have a right, of course, to counsel. And that counsel in the civilian system, one would hope and presume, will zealously represent the defendant's interests and pursue every reasonable legal argument on their behalf. And I think our experience has shown that the American bar has keenly felt its obligation to provide pro bono service in this context, even when the people being served are terrorists bent on destroying the United States government. And that's fine. But we ought to expect that this process will be at all easy. It will be hotly contested from day 1 to day last. And it ought to be. One of my most important points here is that compromises we make in the civilian system to convict these defendants will come at great cost systemically. if you compromise things like the right against compelled self-incrimination in this context, why not in other contexts? And that's a very serious challenge for the justice system. And it's going to be a very serious challenge to whatever poor, hapless district court judges get assigned to try these cases. Because those judges, assuming it's more than one, will have their lives and careers ruined. There will be misery from day one to day end. Ask Judge Brinkema how much fun the Moussaoui trial was for her. So what are the issues? What would be the legal issues? Consider basic criminal procedure protections that we have in this country. Speedy trial rights. Are they gone for these defendants? We've held KSM now since the early 2000s, 2002. What about his speedy trial rights? Are they just gone? Do they not exist? We have to assume, do we not, that these defendants will have in civilian court the full panoply of statutory and constitutional rights according to every criminal defendant in the federal system. Second, what about the actual evidence against the defendants? It's obvious that the government spent a lot of time, and I've worked with a lot of federal prosecutors on matters like these in my past lives, and they've spent a lot of time analyzing the evidence that the government has against, among others, KSM. And that evidence, they're convinced, is enough to convict him of very serious crimes, and I'm sure that it is. But it will be a trifle of the totality of evidence that we have against Kelley Sheikh Mohammed and the others. And the reason why is because we have tons of evidence that's been the product of compelled statements. And it's obvious that evidence from compelled statements will be inadmissible. And it ought to be inadmissible in a civilian court.